Next is State versus O.D.A.C. If counsel could step forward, please. May we please have appearances of counsel?
Good morning, Your Honors. Assistant Bergen County Prosecutor appearing on behalf of the state. Edward F. Ray appearing on behalf of the state.
Deputy Attorney General Caitlin A. Davis for the Attorney General Edwin Kisteria.
John Vincent Saykanic, 1135 Clifton Ave, Clifton, for defendant, respondent, O.D.A.C.
Morning, Your Honor. Joseph J. Russo, appearing as amicus on behalf of the Office of the Public Defender.
Good morning, Your Honor. Alan Silver from Pashman Stein on behalf of the Association of Criminal Defense Lawyers of New Jersey as amicus.
Good morning. Lauren Gottesman on behalf of the Innocence Project, appearing as amicus.
Welcome, counsel. Justice Solomon is participating, as I mentioned earlier, and in this matter. And I'd invite, since we are blessed with a number of counsel here today, I invite counsel to incorporate arguments that have preceded your presentation to the extent that makes sense. Mr. Ray, please go ahead. Counsel, sit down. Mr. Ray, you're welcome to take your mask off.
Good morning again, Your Honors, and may it please the court. I would like to reserve 2 minutes of rebuttal time if necessary.
That's fine.
The state submits that the dissenting judge in this case was correct. The majority failed to defer to the fact and credibility determinations of the trial court. I will first address the trial court's findings. Then I will discuss how the Hackensack detectives' improper comments during defendant's 37-minute interrogation for suspicion of aggravated sexual assault of his girlfriend's granddaughter when she was between the ages of 11 and 13 years old did not deceive defendant. Finally, I will comment on the interrogation as a whole. 3 of the trial court's findings in particular support its conclusion that defendant's Miranda rights were not violated and that his statements were voluntary. First, defendant's prior negative experience with police interrogation. Second, defendant's invocation of his right to counsel, which ended the interrogation.
Please try to keep your voice up, counsel.
Yes, Your Honor.
Thank you.
And third, the trial court's rejection of defendant's testimony that he only spoke with police because of the promise of confidentiality. That testimony was demonstrably false because defendant made incriminating statements, including that the victim's estimate of the number of sexual assaults was, quote, too many, before the confidentiality comment. Now, with respect to the police misstatements, the state acknowledges that certain comments by the Hackensack detective were improper. However, those comments must be placed in context. After the Hackensack detective's confidentiality and second formality comments, for example, defendant, who was clearly not deceived, insisted that whatever he said was, quote, going to work against him. Defendant's comment was a direct reference to his prior experience with police interrogation. He specifically admitted that this was not his first case and that when he spoke to the police in the past, it did not work out in his favor. Moreover, just before the confidentiality comment, defendant requested that the detectives turn off the recording, and they unequivocally refused. The BCPO detective then offset any harm from the second formality reference because he confirmed that those were defendant's rights and acknowledged that whatever defendant said could be considered by his bosses or even a judge or a jury. Finally, addressing the interrogation as a whole, defendant's words and actions show his voluntariness. For example, defendant deflected responsibility. Asking whether a case was being opened, he sought strategic advantage in learning what evidence the police possessed. Lastly, defendant, a 43-year-old businessman who owned and operated his own trucking company, appeared calm, calculated, and in control throughout the interrogation. The video, which the trial court had the opportunity to view, shows defendant with his arms folded as he was leaned back in his chair for most of the interrogation. When detectives recounted the allegations, instead of withdrawing, defendant nodded his head in agreement and stated, quote, yes, and okay. To conclude, the state submits that the majority's decision, which disregarded the aforementioned fact and credibility determinations of the trial court, cannot stand. That concludes my preliminary statement, and I welcome any questions from the court.
I take it from your statement and from your written submission, you don't dispute that there were a number of improper statements made during the course of this interrogation. Is that correct?
Yes, Your Honor. State acknowledges that there were certain misstatements that were improper by the Hackensack detective.
And without spending too much time on it, I just want to confirm three of them. The use of the term formality is one that should not have been used and was improper. Do you agree with that?
Yes, Your Honor.
And the references to confidentiality, this stays between us, was also improper. Do you disagree with that?
I do not, Your Honor.
And the statement, "This is only going to help you," was also improper. Do you disagree with that?
I do not, Your Honor, but I would add that those comments must be placed in context, and there were several instances where the detectives, one of the detectives cured the harm from the other detective's misstatements, and also defendant's prior experience with police interrogation demonstrated that he was not deceived by those misstatements.
And that prior experience you're referring to, how many years before was that? Was it in the nature of 25 years?
That sounds correct. I believe it was at some point in the 90s.
So is there any time limit that one might apply rationally to a prior encounter with law enforcement?
Not that I'm aware of, Your Honor, but defendant clearly remembered the interaction with police. He referenced it in his during the interrogation. He said, you know, just not.
So if I could, I wanted to come back to the three areas. Step back from this case and tell us, what would the takeaway be to this officer, to other officers in cases like this, if, having made multiple improper statements of that nature, the defendant's statements were admitted in evidence?
Well, Your Honor, the court has two roles, one of which is to shape police conduct, of course, but the other area is to vindicate a person's Miranda rights when there has been a clear constitutional violation. Now, this court can and should not condone any of the comments by the Hackensack detective. But there was no clear Miranda violation, and that's simply a balancing test here. So there's no need, without a clear constitutional violation, to vindicate or to suppress the statement here.
Are multiple efforts undermining the significance of Miranda warnings a matter of constitutional concern?
If I understand your question correctly, I mean, the statements have to be put into context to determine whether there has been a Miranda violation. And if I may, I would like to go through each of the misstatements and explain my position more specifically.
But before you do that, and I don't mean to stop you from doing that, I just want to ask you this question. Since you have raised the fact that this defendant had some prior experience with law enforcement, that being the case, let's accept that. Should the person being interrogated start out with the premise that the police are lying to him, even if he's had prior experience? Should that be the default position of the person who's being interrogated? The police lie to me. Should that be the case?
Well, Your Honor, it has to be from the defendant's perspective about whether those lies had any effect on him.
Well, that's what I'm asking. Should the default, is it fair to say that a person being interrogated should be willing to accept that the people talking to him are telling him the truth, if they're police officers? Would that be fair?
No, Your Honor. I mean, the
No?
court has held that police misrepresentations are just one factor in determining, under totality of the circumstances, whether someone's.
Okay, so let's take. So you're saying police misrepresentations are okay in certain circumstances? Are you saying that?
I'm saying that they're just one factor to be considered. in
Okay,
the
so
totality of
so when they can repeatedly hear say that they're going to help him, I'm looking at page 18, but this is just one example. Our two primary goals here, this is the detective, are to make sure that the children are safe and that you seek the help that you need. That's one. Our primary goal is to seek, that you get to seek the help that you need. And that's repeated. That wasn't their primary goal, was it? That wasn't true. They were trying to get a confession from him, correct?
I mean, that's correct, Your Honor, but there's also the defendant's perspective that has to be taken into account, not simply the interrogator's words.
Let me ask you this question. At this point, 2022, knowing that there are a number of false confessions that are elicited, why should we accept that misrepresentations can be made to a person who's being interrogated? Why is that okay? Why should it be okay? And why should it not affect judicial integrity? Why should we as a court accept that?
Because, Your Honor, like I said, the true roles of the court are certainly to vindicate Miranda violations when they occur, but simply having a bright line or per se rule whenever there has been a police misrepresentation, unfortunately...
Even if we don't have a bright line rule, just saying, from this point forward, you are on notice, don't be lying to the people you're interrogating. We'll still use the totality of the evidence, but we're saying that's not an okay practice. It's not okay to lie. You're a law enforcement officer. You're representative of the state. Don't be telling people that you're going to give them help when you have no intention of doing it. Don't tell them that the Miranda rights are a formality. Don't tell them that this is just between you and me. That's not okay. Why shouldn't we as a court be saying that?
Because, Your Honor, like I said, it goes to the issue of whether police misstatements had any effect on a defendant. And if we have a rule where a police cannot tell lies to a defendant, we might have situations where voluntary, otherwise voluntary statements where there has been a police lie do not come in. We might have a situation where police can't cure the misrepresentations that one or other detectives make during the interrogation. And that's exactly what happened here. I mean, if I go to the first formality reference, now the Hackensack detective said just a formality and then started to speak about to tell defendant his Miranda rights. It was a thorough reading of defendant's Miranda rights, a thorough waiver, and that cured the harm from the initial reference. And even the majority acknowledged that this was an offhand remark, and so the state would submit that it was innocuous by its very definition. And what's even more significant is that defendant didn't make any incriminating statements in direct response to this first formality references. Even as the majority acknowledged, the first incriminating statements were 23 minutes later. So this comment in particular, didn't deceive defendant, didn't cause him to make any incriminating statements. As I stated initially, all these comments have to be placed in context. Moving on to the confidentiality comment, and I would note that I would stress again that this has to be considered from defendant's perspective, and it has to be considered under a reasonable standard, as the appellate division noted in State versus Pilar. So from defendant's perspective, he reasonably disbelieved this assurance of confidentiality because the detectives refused defendant's request to turn off the recording. He told detectives a short time later that anything he said could work against him. That was a prior referenced his past experience with police interrogation. And I want to be clear about this past experience with police interrogation. It is not simply that defendant had prior experience in the criminal justice system, which this court has held in certain circumstances is not enough. And in fact, this is an appellate division case, State versus Puryear. Defendant or the detective gave an incorrect explanation of one of the Miranda rights, and the court held that it wasn't cured by defendant's prior experience with the criminal justice system. But we have something more here. We have a defendant saying during the interrogation, pushing back on the detective's comments that he had a past experience with police interrogation, and it didn't work out in his favor. He spoke to police, and he acknowledged it did not work out in his favor. So that's a very specific showing. Now, there's also other context I have to place on this confidentiality comment. Before it happened, one of the detectives, I believe the Hackensack detective, stated that we need to go to your bosses. We need to tell them that you're not a monster. That's on page 14 of the transcript of the statement. The BCPO detective also stated on page 18 that their bosses were involved in a decision about whether to question defendant and when and where to question defendant. And they noted that they waited until he was just discharged from the hospital. And they also insisted to him that the case was not going away. But I also would like to just go back to the credibility findings of the trial court, the fact findings. Defendant testified that he only spoke with police because of the assurance of confidentiality, but that was a completely incredible statement, because he made incriminating statements before the confidentiality comment. Now, even after the confidentiality comment, there was some more curative words from the BCPO detective. He acknowledged that defendant's statement could be considered by his bosses or a judge or a jury. So that's a reference to people outside of the room. And so defendant could reasonably disbelieve the confidentiality comment on that comment as well. Now, there are also no incriminating statements in immediate indirect response to the confidentiality comment. He refused to admit he sexually assaulted the victim. He only said that steroids made him do, quote, silly things. And then he stated not 15, not 10, which is, didn't really add anything to his earlier admission, in which he stated that the victim's estimate of the amount of sexual assaults was, quote, too many. And I would like to just focus a little bit on the majority's decision and its singular focus on this confidentiality comment, but ignoring the other voluntariness factors. This violates the court's holding in LH, which directed courts not to look at any particular factor in isolation, such as police misrepresentations. Now, moving on.
The more misrepresentations there are, the more problematic it is when one looks at the totality of the circumstances, no?
That's correct, Your Honor, but also the majority didn't look at the other misstatements in its holding. It singularly focused on the confidentiality comment. And I would also add, as I stated before, the context matters. The defendant's prior experience with police interrogation matters, and the fact that he...
Just about the fifth time you mentioned his prior experience with a previous case. Do you mean to say that he was familiar with the Miranda process? Is that what you meant to imply by that?
Yes, Your Honor, he was familiar with his Miranda warning.
Do you think you're entitled, if you get arrested, to be read your Miranda rights?
Absolutely, Your Honor.
You're an attorney. You should know them. Should that apply differently for you than for anyone else?
Absolutely not, Your Honor. Yes.
So why is that relevant, that he may have had a prior experience with a police event long ago? Why should we have a double standard in enforcing the Miranda right?
You're correct, Your Honor, that everybody, it's a prophylactic rule. Everybody has to be read their Miranda rights when it's a custodial interrogation. But it just tends to show that he understood his Miranda rights when they were read to him, and he maintained an understanding of his Miranda rights throughout the interrogation.
Generally, prior experience, now we can talk about the gradations of that, but prior experience is considered a factor in the totality of circumstances analysis, is it not?
That is correct, Your Honor, yes.
And as has already been stated, I think by the Chief Justice, that prior experience was approximately 25 years prior to this statement that he gave, correct?
That is correct, Your Honor, but it did not, as I stated, it did not fade from the defendant's memory, and that's why he referenced it during the interrogation. He said, "This was not my first case. I was incarcerated for a mistake I made," and they said the same thing to me. They said, "Talk, talk, talk, talk." And it didn't. And he acknowledged in hearing testimony that it did not ultimately work out in his favor. So he knew that statements could be used against him. He knew that his statements were not leaving the room.
You should have known that that these were false promises of confidentiality. These were false promises of help. That when they said it was a formality, that was false. Should we attribute all that to him? Should that be the standing basis for a person who's had previous contact with the police? Oh yeah, they just lie to you during the interrogation. Don't believe a darn thing they're saying. Is that what you're suggesting?
No,
From
Your
his
Honor.
previous experience with law enforcement?
No, Your Honor. I'm simply saying that this is simply his prior experience is simply one factor in the totality of circumstances analysis. Every case has to be considered differently, and every defendant who's interrogated by police has to be considered differently, including their background, including their past experience with police interrogation. Now, moving on to the second formality comment, defendant was also clearly unpersuaded by this because immediately after it, he said that whatever he said was, quote, going to work against him. And the BCPO detective cured any harm from that comment because he stated, "You're absolutely right. You have 100%, you're 100% right that you don't have to talk to us." And then he acknowledged that the statements could be considered by his bosses or a judge or a jury. So confirming with defendant, affirming that whatever he said could be considered at a later point in time by a judge or a jury. Now, with respect to the last misstatement, which the state acknowledges was improper, that whatever defendant said could only help him, not hurt him, this was at the end of the interview. Defendant invoked his right to counsel not 30 seconds later, and there were no incriminating responses from this comment, so they can be, so the comment bore no fruit, so to speak.
Wait, it wasn't just at the end of the interview. I'm looking at page 18. It was said a couple times. Two primary goals are to make certain that children are safe and that you seek the help that you need. I mean, so that was mentioned at least midway, correct?
Yes, Your Honor, but that's a very different statement from whatever you say is only going to help you.
It's beating the same drum, no?
I disagree, Your Honor. I think it's merely saying that, we're going to get you the help you need. It's not any kind of reference to, his statements or what, whether they would help him or hurt him.
That's on a different plane than the others in the sense that if he is convicted, ultimately, their goal, which they stated, of protecting children in their minds would be met, and presumably, while he would potentially be incarcerated, he would get some sort of help. Is it fair to say that's not a fabrication, that children would be protected and he would get some sort of help as a result of a confession?
That's absolutely correct, Your Honor, and it also provides a nice sort of counterbalance to the facts in State versus LH, in which the police told him, you know, you're gonna get counseling, you're not gonna go to jail, you're not gonna be incarcerated. So this situation here, there's no promise that he's not gonna be incarcerated. It's simply that he would get help.
They didn't add to that help. When we'll get you help in prison. They just said, help.
Right, it just said help.
In the same statement, that officer, excuse me, is making comments about the fact that they know it was a mistake, that he's not a bad person, it's time to just move on. Kind of similar statements, not necessarily indicating we're looking to prosecute you, we're looking to make sure we get the truth and move on from this. Isn't that kind of the essence of what is being stated in that particular passage on page 18?
Yes, Your Honor, it's certainly some form of minimization.
And it's minimization during a period of time in the statement. I think you could agree, looking at that statement, there's a long period where most of the conversation is by the officers. Defendant is not saying much at all. There's a lot of conversation coming from the officers and a lot of this type of reassurance that their goal is to just help him and make sure they get the truth and move on from this. Is that correct?
Yes, Your Honor, there was a period of minimization, but defendant, if I may disagree on one point, was, you know, he was very engaged with the officers. He was nodding his head in agreement during that recitation of the allegations against him. He was saying, okay, I understand, yes. And he wasn't reticent. He was you know, he was calm, he was collected, he was listening to the recitation of the allegations.
But you agree that minimization of the gravity of the offenses is another point that we have said is impermissible. We said that in LH, correct?
Yes, but perhaps not in isolation. That's certainly one other factor to consider under the totality of the circumstances. But again, there's many instances where the detective's comments were cured by the other detective. There are instances where a defendant pushed back on the officers, not believing their promises, or at least the Hackensack detective's promises. And defendant's words and actions during the interrogation, during as can be seen on the video, which the trial court had an opportunity to view and which should be accorded deference, it shows that defendant, he wanted more information about the case against him. He was interested in what the officers had to say about the case. He asked if a case was being opened. He withdrew at key moments. Gave up very reasonably little in his incriminating responses. He said steroid use made him do silly things. He was reluctant to say the number of sexual assaults, saying not 15, not 10, maybe a couple of times, but also maybe not. He deflected responsibility. He stated that the victim's mother had accused defendant of hitting on her, and that was even earlier in the interrogation on page 12 and 13. He's pushing back on the detectives, and that shows that he, you know, his statements, his incriminating responses were voluntary. He blames steroids for causing perhaps to wake up in the middle of the night during when these assaults in question could have taken place. And he also said that the victim's sister always slept in the same bed as the victim, and so casting aspersions on the victim's claims about when the assaults took place. And just remarking on defendant's background, he's a 43-year-old businessman. He ran and operated his own trucking company. It's a short interrogation, relatively 37 minutes. It was a midday interrogation. Police pardon me, the defendant, as I stated from the video, he appears calm. He seems to be in control. He's leaned back in his chair. He has his arms folded. And unless your honors have any questions on that point, I would move on to my last argument, which is that the majority committed reversible error by suppressing the entire statement. And the reason for that is the first incriminating remark happened before the confidentiality and the second formality comment. And so if this court finds that those comments violated defendant's Miranda rights, everything after that violation would be suppressed, but not the prior incriminating statement in which defendant stated that the victim's estimate was, quote, too many. Now that happened obviously after the first formality reference, but that the time span between those was 23 minutes, so it could not have been an immediate and direct effect of that misstatement by the detectives. And I've already stated that the first formality reference was cured by a thorough reading and waiver of the Miranda rights.
I'm sorry, you just said that even though they characterized Miranda warnings as a formality, the administering of those warnings cures that. Is that your position?
Yes, Your Honor.
As long as I understand.
I'm sorry, Your Honor?
As long as I wanted to make sure I understood you.
Sure, and I cited to several cases, not in New Jersey, but a federal appellate court, the Eighth Circuit, I believe, and several states several of the highest courts of states have found that the reference to Miranda, while as a formality, while improper, doesn't render the subsequent waiver invalid, and that's on page 35 and 36 of the state's brief. But unless Your Honors have any questions, the state concludes by submitting that the dissent was correct.
I just have one question. Those cases that you referred to, do they rest on a beyond reasonable doubt standard, as our case law does?
Your Honor, I'm not aware of that. I believe New Jersey is unique in that sense that the voluntariness and the Miranda in general is based on a reasonable doubt. They have to prove the case beyond a reasonable doubt in that sense. But I'm not aware of whether those states also have the same standard.
Please go ahead.
To conclude, Your Honors, the state submits that the dissent was correct. The trial court's fact findings that defendant's Miranda rights were not violated, and I just would like to add and note that the trial court's finding that the defendant's Miranda rights were not violated is a fact finding, and that was supported by substantial credible evidence in the record, and I urge this court to reverse the appellate division's decision in this matter.
Thank you, Mr. Wright. Ms. Davis.
Good morning, Your Honors.
I'm sorry, Mr. Saykanic, we're going to hear from the Attorney General next. We're going to hear next from the Attorney General.
Sorry.
We'll get to you soon.
Apologize.
Not at all.
May it please the court. I would like to start by addressing the court's concern that admitting this statement would condone the municipal detective's misrepresentations in this case. And just note that admission of the statement in no way would be an acceptance of the misrepresentations that occurred here. And this court could make clear in its decision that the statements were improper and that admission is only appropriate because of the other circumstances that occurred in this case.
May I ask you a general question? What is the Attorney General's position on misrepresentations made to a suspect who's being interrogated? Should it be permissible to lie?
Misrepresentation, I'm going to break it into two categories first to answer your questions. Without a doubt, misrepresentations as to Miranda warnings are impermissible. This court's jurisprudence has made that clear. Misrepresentations as to, if we're focusing on the facts of this case, I think the statement is, we're here to help you. Is that, no, because that's a contradiction. The one, we're most concerned about helping the victim and having you receive help. It's the Attorney General's position that those are not lies. They are deceptive, but they are permissible techniques.
Let me ask you this follow-up, because you heard the colloquy with your colleague, and I think the suggestion that misrepresentations, there should be a bright line per se rule that if there's a misrepresentation of any kind to a defendant in the course of an interrogation, then the remedy is suppression. I think I was hearing some suggestion. I'm going to ask you about that in a moment. Hold on for one second. What is it, what function can misrepresentations, what legitimate law enforcement function can misrepresentations play? And by that I mean facts as to what evidence there may be, as to who's come forward as a witness and so forth, that kind of thing.
This court has recognized for over 40 years that certain misrepresentations can persuade a suspect who has a natural reluctance to speak with law enforcement to provide incriminating statements that they otherwise would not provide incriminating statements, but become comfortable speaking that when they otherwise may not.
And that puts us in New Jersey in essentially with every other jurisdiction. Am I correct about that?
Yes, Your Honor.
If New Jersey were to adopt a per se rule that said that any misrepresentation mandates suppression, would we be all alone among the states?
That's true, Your Honor.
First, I was not suggesting, and nor did I, that the totality of the circumstances should not be considered. My question is whether or not we should sanction misrepresentations. And if this court were to say that, it would certainly not be the first one in the country to do that, correct?
Not all misrepresentations are of the same kind, and I think it is appropriate for this court to sanction certain misrepresentations, but not every single type of a misrepresentation, because some misrepresentations are okay. And
there's a big difference between saying you can ignore these warnings, they don't matter, and saying, well, we've had witnesses come forward and say X.
Exactly, yes, Your Honor.
So you're saying that's an okay lie. I want to know the position of the Attorney General. Is the Attorney General saying that it's okay to tell a suspect that 3 people have incriminated you in this crime when that is a total lie? No one has incriminated the person.
I just want to say beforehand, you are certainly to answer every question that is put to you by the bench, but that is not this part of this case. So I don't know that we necessarily want to require the Attorney General to state a position when it's not been briefed and not before us.
Right, Your Honor. There aren't no evidentiary lies in this case, and so really the only focus of the Attorney General's has been on misrepresentations of Miranda warnings, and then the other...
I asked you that question because you said that certain lies are okay. You said that.
Certain misrepresentations.
Okay.
I'm not going beyond that. Yeah, just certain misrepresentations are okay under this court's jurisprudence.
I understand. On the state versus one of the questions, maybe it's not to be totally answered today, is whether or not we should continue to follow the dictates or what was said in State versus Miller, whether or not we're beyond that. Go ahead.
Okay. Well, as far as it applies to statements that were made here that weren't misrepresentations of Miranda warnings, yes, this court should continue to follow that dictate. I would briefly like to talk about why this court should reject a per se suppression rule. just as it did in LH. And the reason that a per se rule would be inappropriate here is because it ignores the imperfect realities of custodial interrogations and our societal interest in acquiring voluntary confessions. And most importantly, it strips trial courts of the discretion that's really at the heart of a Miranda analysis. Under a per se suppression rule, we would be treating all of these police misrepresentations as to Miranda warnings as if they possess the same harmful effect and as if they affected the person who's being interrogated in the same manner. And what's really...
So your view is that the totality of the circumstances is the appropriate test, and that the trial courts have discretion to consider those circumstances and perhaps others as well?
Yes, Your Honor.
Thank you.
Yeah. And in reviewing a trial court's determination when they do employ the totality of the circumstances test, courts should apply a deferential standard of review to ensure that there's sufficient credible evidence in the record supporting the finding of a valid waiver or of an invalid waiver. Yes. And then the final thing I would like to touch on is just that the facts of this case show that both discreetly and collectively a totality of the circumstances review reveals that the municipal detective's misrepresentations did not have the ability to undermine the defendant's understanding of his rights and his waiver of those rights. And as such, the Attorney General urges this court to reaffirm the totality of the circumstances test when evaluating the voluntariness of a Miranda waiver where police misrepresentations as to Miranda warnings occur, and applying that test to the facts of this case, this court should reverse the appellate division decision and find that the trial court's finding of a valid waiver was supported by the evidence in the record. Thank you.
Thank you, Ms. Davis. Mr. Saykanic.
Good morning, Your Honors. I requested 5 minutes for a preliminary statement, and may I make that now?
Yes, please go ahead.
Your defendant respectfully submits that it was the two judges in the majority and not the lone dissenting judge that had it right. The majority did not fail to accord the trial court's fact and credibility-based determinations the appropriate deference it deserved. Preliminarily, the state does not challenge the majority's ruling that the defendant was in custody when he went to the police station. The sole issues to be determined is the question of the voluntariness of the statement and the Miranda waiver New Jersey state issues and the admissibility. To be clear, Your Honors, I'm arguing that this is not only a Fifth Amendment Miranda voluntariness of waiver New Jersey state law violation, but also an involuntary statement induced by a violation of the defendant's 14th Amendment due process rights, which should be inadmissible, not only in the prosecution's case in chief, but also for impeachment purposes, should defendant be tried. Because if I win, he's going to possibly be tried. I misspoke, tried. And that's Mincy v. Arizona, U.S. Supreme Court, 437, 385, 1978. The admissibility of defendant's statement is evaluated under voluntariness standard, judged by the totality of the circumstances, Schneckloff Bustamante, which asks whether, under the totality of the circumstances, the confession is, quote, the product of an essentially free and unconstrained choice by its maker, unquote, or whether, quote, his will has been overborne and his capacity for self-determination critically impaired, unquote. I submit in this case, Your Honors, it is the latter, and defendant's will was, in fact, overborne. Here, the overreaching police conduct violates due process, State v. Smith, 32 NJ 501, 1960, State v. Driver. At this point, I would like to emphasize a most significant fact, Your Honors, that comes to bear most heavily upon the issue before the court. Defendant had just been released from Bergen Regional after 3 weeks after he had self-admitted for severe psychological problems, including suicidal ideation. He had been heavily medicated for this 3-week stay with psychotropic antidepressant drugs, sertraline, which is Zoloft, Xanax, and Trazodone. Not to mention, Your Honors, the poor sleep, diet that a prolonged stay in a hospital will induce. I've never been in a hospital for 3 weeks, but can you imagine anybody being in a hospital for 3 weeks? And defendant was actually on Zoloft when he was questioned. The police knew, and this is the most important thing, the detectives knew defendant was especially vulnerable, as only any normal human being would have been. They knew this. It wasn't like they were looking for him, then all of a sudden, there he is outside the hospital, let's grab him. All defendant wanted to go home, reasonably, was to shower, sleep, see his family. Instead, he gets interrogated at police headquarters. Defendant was in such a vulnerable state of mind. His fragile state of mind is similar to State v. Pickles, 46 NJ 542, 66, invalidating a mother's inculpatory admission to child neglect because it was, quote, extracted by basically unfair means, unquote, as she was questioned immediately after her son's funeral, and her emotional state made her, quote, an easy prey to interrogated pressure, unquote. As explained in the dissent in LH, Justices Patterson and Solomon and Chief Justice Rabner, the real issue is whether the confession resulted from a change of mind or from an overbearing of the suspect's will. That's what we're talking about here. Here, there's no question of police conduct overbore this defendant's will. I rely upon LH. I rely upon state in the interest of AS 203 NJ 131. In that case, an interrogating officer violated a juvenile's rights by telling her that answering questions, quote, would actually benefit her, unquote. An assertion at direct odds with the Miranda warning, quote, that anything she said in the interview could be used against her in a court of law, unquote. Quote, a police officer cannot directly, out of one side of his mouth, utter the Miranda warnings just given out of the other. That's State v. Pilar, 359 NJ Super 249, Appellate Division 2003, where a confession was suppressed as the defendant reassured his statements were, quote, off the record, unquote. I submit that Pilar is a case, like the case before your honors now, that crossed the line. I also rely on State v. Per year, 441 NJ Super 280, Appellate Division 2015, finding inadmissible an interrogator's representation to the defendant that he could, quote, could not hurt himself and could only help himself by providing a statement, unquote, because it contradicted a key Miranda warning. Here, defendant submits there are at least 10 misrepresentations, constitutional violations. Chief Justice Rabiner mentioned 3. The Attorney General in amicus mentions 4. I submit there are at least 10, and I think I have to go through each of these constitutional violations. They're all in the statement. The bottom line I submit is to allow the state to use incriminating statements based upon constitutional violations would sanction governmental deception in a manner that violates the 14th Amendment due process rights. The majority was correct in suppressing defendant's entire statement and not just portions, as defendant was tricked into making a statement and his purported Miranda waiver was not knowing, intelligent, and voluntary, as the detective's misrepresentations about those most substantial rights deprived defendant of the ability to make an effective waiver. Finally, I would like to cite Justice Albin's concurrence in State v. Laura Gonzalez as to the United States Supreme Court's concern over false confessions. And now with DNA, everybody knows how bad false confessions are, how prevalent they are. As quote in Spano v. New York, quote, life and liberty can be as much endangered from illegal methods used to convict those thought to be criminals as from the actual criminals themselves, unquote. And that is my preliminary statement, Your Honors.
Mr. Saykanic, I don't recall the appellate division, either the majority or the dissent, speaking about whether, if the statement is suppressed, it can be used for impeachment purposes.
You know about the voluntariness issue?
Yes. Did it address to the opinion?
Yes, I submit, with all due respect, Your Honor, a due process voluntariness challenge is before this court.
I'm asking, did the appellate division address the question of whether the statement could be used for impeachment purposes?
Well, they vacated the conviction, so, yeah.
I thought their emphasis was on the misleading statements and how they undermine the warnings.
Miranda.
Yes.
Right.
So I think you need to leave that argument for the trial court for another day, if you prevail, because this is an appeal of right based on the rulings in front of the court.
I understand. Does Your Honor want me to tell you why I believe the majority ruled on voluntariness? Because I think it's a significant thing, because I want the whole statement out if I do win. Do you want me to?
You asked for 2 things. You want the statement out, and you want to make sure that it's not used for impeachment purposes, if I heard your opening correct. I'm only speaking to the second point.
Okay.
Did the appellate division address the impeachment question?
Miranda waiver, yes. Miranda waiver issue. That's what they addressed.
Can you tell us where in the opinion it speaks to not using the statement for impeachment purposes? I don't recall it being discussed in that way. This isn't a trick question. I'm simply trying to clarify.
You are tricking me.
No, it's either there or it's not. I don't
Yeah,
recollect.
I'm just trying. They said it's vacated. I'm not, in all honesty, I just don't recall.
Didn't they vacate it on the basis of of their ruling that it should not be, the statement should not be admitted?
Absolutely. Of course, on Miranda. Not voluntary. Well, I submit it was voluntariness as well.
Well, voluntariness is part of the three-part test of knowing, intelligent, and voluntary waiver. So that's all part of the standard that the appellate division applied in suppressing the statement.
Well, I don't want the statement to come in at all.
Mr. Saykanic, let's leave it at this. We understand what you're asking for. Focus on the first of the two items that we've been discussing.
Okay. Your Honor, as to number one, just a formality, which is page 2 of the statement, that's a formality, just a formality. I disagree vehemently with the state's characterization of this most fundamental constitutional violation as, quote, innocuous. The state's trying to make Miranda rights superfluous, Your Honors, and I respectfully submit this court should reject that in the strongest possible way.
So looking at what happened here, and just focusing on that statement early on in the interrogation, is that enough to say the statement should be suppressed?
Yes, I submit it is, because they also reiterated it, and that's number 7.
Don't get there. Don't get there. What I wanted to, it sounded like you were proposing a bright line rule.
Sure.
That if before administering a statement, an officer says it's a formality, that's the end of the analysis.
Yes.
Is that your position?
Yes, but I don't think that is my only argument. I would love that, but I don't think I have to have that. And I believe amicus is going to certainly address that.
You understand we're going to write an opinion that applies to many cases beyond this one.
Absolutely.
We're looking to understand your principled view of the law, and I think you've told us it's a bright line rule.
I submit we need a bright line ruling, a finding of police stating that Miranda rights are, quote, just a formality, unquote, should result in automatic suppression of the entire statement. The bright line rule is the only way to make the police stop doing this, Your Honors. There's no other way. I analogize it to the exclusionary rule. It's about deterrence to stop police misconduct. And State v. Patton, 362 NJ Super 16.
Counsel, if there were no misrepresentation, if every other question went according to Hoyle, and the only wrongful comment was the one on page 2, it's your position that the entire confession should be suppressed?
Correct, yes. Okay. Like State v. Patton says, they had a bright line rule. Police fabricated an audio tape of an eyewitness. The officer may believe he was a witness, and they played it, led the defendant to confess. Obviously, that's physical evidence. That's not this. And then State v. Chirikoskovich, 37 NJ Super 125, it was a fictitious DNA report. The court held, since our courts never recognized the practice of fabricating evidence in order to secure a confession, Patton did not constitute a new rule of law and thus could be applied retroactively, at least to pending cases. And again, these two cases involve the creation of fake, quote-unquote, evidence. But the principles apply equally here. You know, the state is just chipping away at Miranda completely. And when you say it's just a formality, you're negating Miranda. That's what you're doing. It's State v. Bernal-Taylor, 400 NJ Super 581, Aptiv 2008. That was an invocation case. Officers said that the reading of Miranda rights was, quote, just a formality, unquote, and the statement was suppressed. Again, the bottom line, the only way to make the police stop minimizing and chipping away Miranda is by stating it and by stating it's just a formality, as if this court orders them to do so. Now, I submit the second constitutional violation is on page 23 of the statement. It's at 23. Oh, I don't know if Your Honors want me to, I apologize, but he made an inculpating statement. I mean, Your Honors are aware of that. He made an inculpating statement based upon the just a formality, the one just a formality, and that's at 2325. They've said the number she gives us as far as the assaults, is that too many? It's too many. That's at 2325. Is it 15 times that this happened? 15 times? 20 times? I don't think so. You don't think so? I don't think so. So that's inculpatory from the first constitutional violation. So that's one inculpatory statement he makes. Then I get to my second constitutional violation. This is on page 23 at 2351 in terms of minutes. Defendant requests that the recording be turned off. And he's advised by the police, quote, that's a law, that's to protect you, unquote. Now, Your Honors, the electronic recordation rule 317 states, unless one of the exceptions set forth in paragraph B are present, all custodial interrogations conducted in a place of detention must be electronically recorded when the person being interrogated is charged with aggravated sexual assault. He was a suspect in that, and that's what it says. It would apply to that, very serious crimes. However, Section B4 states, quote, electronic recordation must occur unless a statement is made during a custodial interrogation by a suspect who indicated prior to making a statement that he would participate in the interrogation only if it were not recorded, unquote. So I submit that that was a misrepresentation. That's the second substantial constitutional violation in this case. Now, there are 3, 4, 5, and 6 constitutional violations, and they're all pretty much related. Number 3 is at 24 minutes. Quote, what we talk about in here is between us, unquote. That's page 23. At 24:14, number 4, it's confidential between us, unquote. Page 23. Number 5, at 24:16, quote, it's staying between us, unquote. Page 23. And the 6th, at 28:17, quote, once you get this off your chest, you, me, and him, we're going to feel 1,000 times better, unquote. Now, that last one, it's clear that this refers to only the 3 of them, defendant and the 2 officers being privy to what defendant says in the interrogation room. The implication is that no one else would ever hear this statement. It would stay in a room between them, i.e. confidential. These 4 constitutional violations are similar to the violations in Pilar, where the statement made off the record was obtained in violation of Miranda and found to be involuntary. And this is Pilar. First, quote, such a misrepresentation directly contradicts and thereby neutralizes the entire purpose of the Miranda warnings, unquote. And second, such misrepresentation may, and in Pilar did, render the statement involuntary. That's exactly what we have here, 4 times. And Pilar on the Miranda issue said basically any request to, quote, speak off the record, unquote, cannot constitute a knowing and intelligent waiver of Miranda rights, especially the advice that anything a suspect says can be used against him in a court of law. They're negating Miranda with this. And I just want to bring something up. This flurry of psychological punches by the officers got to the vulnerable defendant and led to his statements about injecting himself. Those are inculpatory statements. I don't know if Your Honors want me to read his inculpatory statements. I'm sure you're familiar with that. Now, that was 3, 4, 5, 6. Number 7 was the formality repeated. So 8 and 9. Number 8 will be at 28:17, quote, so whatever you're saying here, it may be hard to believe that it's not going to work against you, unquote. That's at page 27 of the statement. And number 9, at 35:28, quote, anything you say, like I said, is not going to hurt you. It's only going to help. Page 33. And I would cite Justice Albin's concurrence in Gonzalez that the use of lies by the police during an interrogation and whether that practice should continue to be sanctioned by our courts, we have held that false assertions, such as telling a suspect that, quote, the truth would be helpful, unquote, and, quote, set him free, unquote, LH, and that answering questions, quote, would actually benefit her, quote, AS, contravene the Miranda warnings. See also State v. Perrier, finding a Miranda violation when the interrogating officer told the suspect he could not hurt himself and could only help himself by providing a statement. And, of course, the defendant does, in fact, inculpate himself after that. And in all honesty, Your Honor, number 9 at 35:28, he does not inculpate himself after that one. But it's the pattern that's important. I mean, think about it. They knew where he was. They could have waited for him to go home. They grab him when he first comes out of the hospital, And all of these constitutional violations have to be considered in that context, Your Honors. Now, I would like to very briefly go through the totality of circumstances, because obviously that's, Steklov v. Bustamante, that's key to our determination. The totality of circumstances to determine whether it was knowingly, intelligently, and voluntarily made. Of course, the state has the burden of proof by reasonable doubt, the highest standard there is. The suspect's age at the time the statement was made, he was 43. His education and intelligence, he's a high school graduate, Your Honors, and this is different than Justice Patterson's, the defendant in LH, where he was sophisticated, well-educated. This man is not. He was born in Ecuador and came to the United States when he was 16, and his first language is not English. It's clear from the video. He has an accent, so that's another factor that distinguishes LH. The descent in LH. And again, I can't repeat this enough. The involuntary statement is due to his vulnerability. He's coming out of a hospital after being in there, doped up for 3 weeks. You know, these psychotropic drugs, what they do to a person's mind. It's so invidious for the police. They knew that. They knew why he was there, suicidal ideation. Why would they do that? Think about it, how bad that really is. They could have just waited for him to go home, wait a couple days. He wasn't fleeing. There was no urgency here. Number 3 on the Schneckloff factors, advice as to constitutional rights. I submit they were vitiated from my prior arguments. Number 4, the length of detention. Obviously, it was only a 37-minute statement, but he waited 2 hours at the Hackensack Police Department before being interrogated. He hadn't eaten, and they gave him, he told me, a really bad sandwich to eat. And you get out of hospital with terrible food, you get picked up by the police, and they give you even worse food.
Saykanic, I don't want to stop you, but
Go ahead.
Remember that we're here because of the legal issue
Yes.
that the majority and the dissent divided over with
Correct.
respect to the misrepresentations.
Yes.
It's not a full-blown suppression hearing that we're conducting now.
I apologize. Number 5, the factors, whether questioning repeated and prolonged in nature. I submit it was, even though it was a short statement. Whether physical punishment or mental exhaustion involved. I submit that there certainly was mental exhaustion involved. Again, who sleeps in a hospital? It's impossible. 3 weeks, not sleeping, psychotropic drugs, bad food. Number 7, suspect's previous encounters with the law. There was one prior, very old, and I cite per year at page 297. The trial court also correctly found that the detective's incorrect explanation of Brown's Miranda rights was not cured by Brown's prior contact with the criminal justice system. Here, the state showed only that Brown had been arrested in 2005 and pled guilty in 2008, but did not offer proof that such prior experience enabled him to understand his Miranda rights, despite the detective's incorrect explanation of his Miranda right number 2. Absent a more specific showing by the state, the trial court did not err in making such a finding. So Pierre is right on point as well, Your Honors. Unless you have any questions, I submit. I have 3 amicus behind me, amici, who are invaluable with their assistance.
Thank you, Mr. Saykanic. Mr. Russo.
Good morning, Your Honors. May it please the court. The appellate division got it right. The Hackensack detective did a blatant end around bedrock constitutional guarantees when he made 8 statements that neutralized, contradicted, and misrepresented the Miranda warnings, rendering the fundamental protections guaranteed by the Fifth Amendment and Miranda meaningless. The Office of the Public Defender is seeking a 2-pronged bright line rule, so suspects isolated in windowless interrogation rooms, are not stripped of their capacity for self-determination by misleading statements like the ones made in this case in a persistent pattern. First, interrogators must be barred from neutralizing, contradicting, or misrepresenting the Fifth Amendment and the Miranda warnings by stating to suspects that their words will not be used against them or that their conversations are confidential. As noted by Justice Alban recently in Gonzalez, the failure to abide by this simple dictate may lead to the suppression of a suspect's statement. And as noted in Pilar, cited by Mr. Saykanic, a police officer cannot contradict out of one side of his mouth the Miranda warnings just given out of the other. When officers talk out of both sides of their mouths on issues of constitutional import, such as the Fifth Amendment, a knowing, intelligent, and voluntary waiver cannot be proven beyond a reasonable doubt. Second, interrogators must be barred, totally barred, a per se rule, from utilizing language which minimizes the constitutional significance of the Miranda warnings by referring to the rights as a mere formality, as was done by the Hackensack detective in this case, not once, but twice. Here, as Mr. Saykanic indicated, and by my count, there's a total of 8 neutralizations, contradictions, or misstatements of Miranda, 7 of which occurred post-Miranda. Now, I think this might be the most important factor here. Notably, 6 of the detective's statements occurred in rapid-fire succession within less than 5 minutes. And I watched the video several times. Within less than 5 minutes, after the defendant requested that the recorder be turned off, And that's at 23:51 to 28:20 timestamped on the video. Less than 5 minutes. I'm not going to go over all those.
Could you just repeat those numbers?
Yes. 23:51, elapsed time, that is, Justice Patterson and Justice Rabner. 23:51 elapsed time to 28:20 elapsed time. Not the actual time, but the elapsed time. I'm not going to go over those 8 statements, but clearly, telling a suspect that a statement will not be used against him or that his rights are just a mere formality, as the detectives did here, is a blatant misrepresentation that not only guts the protections of the Fifth Amendment, but also overbears a suspect's will and strips him of his capacity for self-determination. This court's decision in LH is instructive, and I looked at it very closely. Although LH is a due process voluntariness case, this court recognized that certain lies may overbear a suspect's will and render a confession involuntary. And this is key. The LH majority and the LH dissent recognized that the officer's promise in Pilar that the defendant could speak off the record rendered the statement involuntary and the waiver invalid because it contradicted a key Miranda warning. Both the majority and the dissent were in agreement on that principle. Clearly, if the singular statement in Pilar was sufficient to render the waiver and the statement involuntary, then the extensive misrepresentations by the Hackensack detective in this case mandates the same result. There are 3 additional reasons why the dissent got it wrong, and I'll try to be brief. First, I argued SS before this court in 2017, and I got a lot of questions from the court, and I know the opinion well. And I litigated the motion at the trial level after the first reversal. But in my view, the dissent hides behind the deferential standard of review set forth in Elders, Gamble, and SS. While factual determinations are clearly entitled to deference, we all know that, so long as there's substantial credible evidence in the record, or if the factual findings are clearly wide of the mark, we reject them. But appellate courts owe no deference, as this court is well aware, no deference whatsoever to conclusions of law, which are reviewable de novo. Determining the legitimacy or the validity of a waiver is a legal conclusion not entitled to any deference whatsoever. Second, the dissent and the state concede, and by the state I'm talking about the Bergen County Prosecutor's Office and the Attorney General, they both concede that the Hackensack detective improperly referred to the Miranda warnings as a formality and improperly told the defendant that the entire interrogation was confidential. The dissent nevertheless states that in context, those statements did not vitiate the proper Miranda warnings. But in my view, in my review of this record, on behalf of the Office of the Public Defender, the dissent only analyzed the factual context of the detective's statements, ignoring bedrock Fifth Amendment principles. The dissent never once applied the law, the governing law, never referred to LH, AS, per year, or Pilar anywhere in the dissenting opinion.
Can I ask you a question, Mr. Russo? Your principled articulation of the law is not what the law is right now. You're not asking for a totality of the circumstances test. You're advancing a bright line rule such that in a case like this, anything said after the first use of the term formality must be suppressed. Is that correct?
That is correct, Your Honor.
And just to test that a little bit.
Yes.
So if the suspect happens to be a lawyer, a law professor, someone well-versed in the Fifth Amendment, doesn't matter. As soon as the word formality is used inappropriately, end of story, end of analysis. Is that your position?
That is correct.
Why does that make sense?
Because the police, number one, must be deterred. Number two, the police must have guardrails on this confession highway. And number three, police ought to be transparent and truthful to suspects in the interrogation room. Now, when I say truthful, there's a lot of discussion between yourself, Justice Albin, and the Attorney General on this issue. I recognize that the case law in New Jersey, and as Justice Patterson said, throughout the country, is that police can make misrepresentations, can lie to suspects. I certainly recognize that. But the constitutional divide, the constitutional dividing line is at when you misrepresent Miranda, when you misrepresent a bedrock Fifth Amendment principle, and I'm not talking about a prophylactic rule of reading the Miranda rights. I'm talking about misrepresenting the most fundamental principles that we have in a democracy. Now, I want to go back to the fifth.
The test is, as I understand it, whether there has been a knowing, voluntary, understanding waiver of unlearned in the law, statement can't be used against them. Their statement is involuntary by the invocation of the use of the term formality, right?
That is correct.
Are you arguing that that undermines the voluntariness as to the particular individual?
It undermines the voluntariness, Mr. Chief Justice, and it also undermines whether it's a knowing, intelligent, and voluntary waiver.
How does it do so for a learned defendant?
Because if you go, the totality of the circumstances test is not workable in the context of misrepresentations of bedrock principles.
Right, but how does it, if you could answer the question that I'm struggling with, how does it do so in the case of a learned defendant?
Because the totality test should not apply when we're dealing with the gutting of a Fifth Amendment principle. And I think that we don't look to the totality test to look at prior experience. For example, with law enforcement, the interrogation rises and falls on each individual interrogation. And I think this is similar to Reed. If you take a look at what we've done, Mr. Chief Justice, and as this court is aware, I went through our confession outline, Jim Smith's confession outline, and I went through all the case law, and I come up with five per se rules that we have, 5 bright line rules we have in the confession space. That's Hartley, Payton, Patton, and Prescia. And then in the knowing, intelligent, and voluntary space, the waiver space, so to speak, we have Reed, AGD. And both in Reed and AGD, we rejected the totality test because of the substantial rights that were at issue. In Reed, of course, when there's an attorney in the waiting room or an attorney who wants to confer with the client, that's a bright line rule. We suppress the confession if that is not permitted, and we don't look at the totality. And in AGD, of course, if the defendant is not told the suspect that there's a complaint sworn out for his arrest and there's a warrant for his arrest prior to the interrogation, that is automatic suppression.
So hypothetically, let's assume we have a public defender, not from the New Jersey office, of course, but from another state who is being interrogated in New Jersey. Officer says, this is a formality, I need to go through my rights, and go through the rights and then reads them, and then the defendant, public defender, says, I'm very familiar with the rights, and what you've said is wrong, and I know that it is wrong, but I'm willing to speak with you, fully understanding what the law is and what my rights are.
I think
Tell me
with a
why
bright
that-
line
tell
rule,
me why
there will
that must
certainly
be-
guilty people that go free with a bright line rule.
Say that again?
With a bright line rule, there will be guilty people, guilty individuals who have committed crimes.
Not a matter of guilt or innocence.
Yes.
It's voluntariness. That's at the heart of the test. Explain why in a situation like that, the answers given are not voluntary.
Because Miranda is never a formality. And when you say it's a formality, just like the court in Berno Taylor said, now Berno Taylor was a much different case, I recognize, but there was 11 invocations, 11 refusals to sign the waiver form. But in Berno Taylor, the court did address, the appellate division, the case was never certified to the Supreme Court, but the appellate division did say that referring to the Miranda waiver form as a silly piece of paper or as a mere formality really guts the Miranda principles. That was in dicta because it really was an invocation and a refusal to sign the waiver form 11 times. But the court did address its serious concern with referring to Miranda as a formality, which was done twice in Berno Taylor, and also referring to the Miranda waiver form as a silly piece of paper. I think this is one of those circumstances, Mr. Chief Justice, just like in Reed and AGD, where a bright line rule is the only rule that is workable. I don't think it's necessary to look at the totality of the circumstances test. And it's borne out in this case. The Attorney General and the Bergen County Prosecutor's Office is arguing that somehow this defendant's experience with law enforcement, dating back to 1994 and 1995, somehow makes him a sophisticated legal practitioner. And somehow that negates all of the 8 neutralizations, contradictions, and misrepresentations of Miranda.
I just want to understand your argument. Your bright line rule is to any comment that would undermine the vitality of Miranda. You're not talking about general voluntariness. You're talking about contradictions of Miranda, such that after the police officer says anything that you say may be used against you, and then he says, you know, the things that you say can help you. Is that, I'm trying to understand what your bright line rule is, including and excluding. Go ahead.
Bright line rule applies to both the waiver and to voluntariness.
Oh, so you're saying any misrepresentation, period. You want the court to completely abandon the totality of the circumstances.
I see it very similar to LH in many respects, where in LH, the statement was, detectives told defendant that the truth would set him free.
Look, we can have a totality of the circumstances test, and yet there can be certain misrepresentations which are so cutting and so vital that standing alone, it may render the statement involuntary. That isn't abandoning the totality of the circumstances test. Do you understand?
I do understand, and my response would be that the police ought to have bright line rules, and that we're going to be here regarding gradations of misrepresentations, gradations of neutralizations.
And if one category of misrepresentations ends the issue, that's a bright line rule which you are seeking.
That's
right?
correct, Justice Patterson.
Totality of the circumstances, as I understand it, involves the judge looking at a number of circumstances with none of them being the be all and end all.
That's correct.
What you're urging is a bright line rule that would
Yes, Justice Flores.
Yeah.
And I do recognize that under a totality of circumstances test, it's not a quantitative analysis. It may have been said by this court in Prussia, but it's not a quantitative analysis. It's a qualitative analysis. And one very, very serious misrepresentation could carry the day on a totality test as well. I do recognize that.
Right, but you're looking for, what you're characterizing as the rule, you're looking to add to the list of 5 of bright line rules.
Looking to add in the waiver and voluntariness context, add this case to read in AGD. So there's a bright line rule. Otherwise, we're going to be arguing forever regarding what constitutes significant enough neutralization, what constitutes a significant enough contradiction, what constitutes a significant enough misrepresentation.
So are you suggesting you don't want to come back and argue in front of us again?
I would love to, Your Honor.
I mean, there are Mr. Russo, there are cases out of state where courts have said that lies and deceptions are impermissible. They've come straight out, but they have made those statements within the context of their own totality of the circumstances.
Oh, well, that may
Our state so far says certain lies and deceptions are still okay. I mean, that's how we differ from those states.
It's certainly a better rule than where we are now. But I think I was discussing this with a very good trial attorney that I worked with when I was in the Hutch region, who's tried hundreds of cases. And one of the things that she said was that, we've been toying around with this neutralization thing for 15 years. And it's interesting that Pilar and Puryear, 2 appellate division cases, are really the essence in this area of the law. We have AS, but AS involved the juvenile, right? But the essence of our case law, it goes back to Pilar and Puryear. And I really think Pilar especially is very, very well reasoned, because Pilar addresses both voluntariness and the lack of a knowing, intelligent voluntary waiver when there's a substantial neutralization.
We said it in LH. We've said it's recently.
Well, that's actually correct, and I apologize, Justice Alban, and I actually have the language right here. Thus, a police officer cannot directly or by implication tell a suspect that his statement will not be used against him because to do so is in clear contravention of the Miranda warnings. That's correct, the recent pronunciation in LH. And it's noteworthy, Justice Alban, and I want to get back to this. This is my second point where I have a problem with the dissent. But nowhere in the dissenting opinion did they apply the relevant precedent to the facts. And there's no issue of facts. The Attorney General in the prosecutor's office talks about credibility determinations. There's no credibility determinations in this case. You're talking about 8 statements that are not in dispute. There's 8 statements that are on the videotape. They're not in dispute. So all we simply have to do is apply the relevant jurisprudence, LH, Pilar, Puryear, to those 8 statements. Did it gut the Fifth Amendment? Did it gut Miranda? I see no way in which the state can prevail when there are statements that are pattern and practice. I call it purposeful, but that does not have to be a finding of purposeful. When I used to do litigation in the False Claims Act space or work in the False Claims Act space.
Mr. Russo, forgive me for interrupting. I'm just looking at.
I'm sorry.
Can I ask you with 2 amici to follow, to try to draw your argument to a close and cover the points that remain very succinctly?
Sure. The Hackensack detective, in closing, Mr. Chief Justice, the Hackensack detective patently undermined one of the essential Miranda rights. It was a purposeful effort demonstrated by pattern and practice of misrepresentations to deny the defendant his ability to exercise his most sacred privilege, the privilege against self-incrimination. Police have been manipulating Miranda for decades, extracting confessions by disarming the Miranda warnings. Because the right against self-incrimination is so fundamental, deterring police from contradicting Miranda does not lend itself to a totality test. The Office of the Public Defender is seeking a bright line rule with respect to when police utilize neutralizations, misrepresentations, or contradictions of our most sacred fundamental right, the right to be free from self-incrimination. Thank you.
Thank you. To remaining counsel, we tend to break at around 12:30. I want to keep going forward. I tell you that we'll go a little bit beyond, but if it takes much, much longer, we may need to carry the argument over till 1 o'clock.
Sorry, Judge, I couldn't quite hear you. My old ears are not working through the mask real well.
We tend to break at 12:30. And please be mindful of that as you present your argument.
Thank you.
Thank you. Mr. Silber, go ahead.
Good morning, Your Honors. In our brief, the ACDL of New Jersey cites the social science research that demonstrates that the current Miranda warnings are simply not being understood by suspects. Moreover, other research, as well as the cases that have come before this court, demonstrate that interrogators too often dilute and minimize the power of Miranda warnings and even lie to suspects for the express purpose of inducing the suspects to waive important constitutional rights, as was done in this case. The assistant prosecutor admits that those comments are improper. The attorney general says they're impermissible and then asks this court to permit them. Thus, the ACDL advocates, as Justice Albin has written, it's now time to revisit the Miranda procedure to see if they're accomplishing the intended results, and if not, to see what changes must be made in order to make them effective. Justice Albin crystallized the issue in concurrence in Gonzalez when he wrote, "This court will have to reassess its jurisprudence, which gives officers leeway to tell some lies during the interrogation. We have to determine whether sanctioning deception and trickery in the interrogation process offends judicial integrity and outweighs the benefits of eliciting a number of true confessions." These seem to me, when I read them, to be rhetorical questions, and I think Justice Albin proved that when he concluded, and I quote, "Law enforcement use of lies during interrogation is a practice that's inconsistent with the ideals of our criminal justice system." Amicus, we urge that this is the case to undertake the review that Justice Albin advocated for. The police trickery and deception in this case is acknowledged by the state. This court should decide, in Justice Albin's words, whether sanctioning deception and trickery in the interrogation process offends judicial integrity. Amicus submits that when the police engage in deceit and trickery to convince a suspect to waive his fundamental rights, as the state acknowledges the police did in this case, the Hackensack detective, a statement given by the suspect cannot be voluntary as a matter of definition. How can a waiver be voluntary?
I think you may be overstating the state's concession on this.
Pardon me?
I think you may be overstating the scope of the state's concession with regard to these statements. I believe what they said was they conceded that they were improper statements.
Right, and I said improper is one word. I used the word inducement. I believe if we were on the street word would be con. That essentially the police are conning the suspect into giving the thing.
All I'm saying is that you were speaking for the state and the AG, and I think you may have gilded the lily a bit with respect to what they conceded. That was my only point.
Yeah, fair enough, Judge, and I apologize if I did. In any event, what I was saying is, how can a waiver be voluntary when the interrogators have provided the suspect with deliberately false information, and as Justice Albin points out, from an authoritative source, where the very purpose of the false information is to deceive the suspect into waiving his constitutional rights? Therefore, Amicus believes this court should hold that statements by the police that undercut, contradict, obscure, or mislead a defendant about Miranda warnings must result in suppression, whether or not they're the cause of the waiver. And now to the heart. To accomplish this, the totality of the circumstances test should be abandoned if the nature of the interrogation contains police lies, trickery, or deception. The goal of the vast majority of law enforcement lies is twofold. One, to have the suspect avoid asking for counsel, and two, to have the suspect waive his right against self-incrimination. Here's what the totality of circumstances has been held to permit. Quote, "The totality of circumstances test makes sense because a suspect will have a natural reluctance to furnish details implicating himself." And this is the important part. Thus, efforts by an interrogating officer to dissipate reluctance and persuade the person to talk are proper. Indeed, the Attorney General supports giving officers leeway to tell some lies during the investigation. And I'm taking that from page 27 of the Attorney General's brief, quoting State versus Miller and State, 1978 case, and State versus Galloway, a 1993 case, both of which has whiskers on it in some ways. The interrogators lies to suspects in order to, quote, dissipate the natural reluctance of the suspect and persuade the person to talk will never stop unless this court mandates suppression. Because every effort to again, persuade the person to talk, to dissipate the reluctance, is a way of undercutting Miranda. At least I was unable to think of a single effort that could be made to persuade the suspect to end his reluctance and to talk that isn't dilute or misrepresent Miranda.
So your position is that if there is an effort to persuade a suspect to talk, there's suppression is the remedy.
I didn't hear the last three words.
That suppression is the remedy.
Yes.
If the police make an effort to try to make someone talk, persuade them to talk, you're saying the remedy is suppression.
Well, there's one little piece in between. What I said was I could not conceive of an effort to make someone talk that wouldn't dilute the Miranda warnings. If that's true, if I'm right about that, then yes, the answer to your question is yes.
That would seem to outlaw interrogations, period. That definition.
Not outlawing interrogations, period, but asking that the Miranda warnings not be diluted, and frankly, Judge, I'll give at the end an example of the kind of thing that the ACDL is asking the court to examine, whether by appointing a special master to examine or holding a judicial conference. But we need to dive into this to see what the problems have been and to correct those problems. Judge Weisbard in Pilar set out a bunch of cases, state cases and a Third Circuit case, which did hold that there was a bright line rule. And I thought that it was important that the judge pointed out what the doctrinal underpinning for the conclusion that statements made in reliance upon official promise of favorable treatment are inadmissible. And he cites Bram versus the United States, 168 U.S. 532. We're talking about 1897. And Bram says, to be admissible, a confession must be free and voluntary. That is, must not be extracted by any sort of threats or violence, and I underlined any, or obtained by any direct or implied statement, however slight, nor by the exertion of any improper influence. A confession can never be received in evidence where the suspect has been influenced by any threat. And here's the reason that underlies Bram, and it's one that I'm going to suggest the state ought to adopt. For what Bram wrote and Justice Weisbard cited with approval, for law cannot measure the force of the influence used or decide upon the effect upon the mind of the suspect, and therefore excludes the declaration if any degree of influence has been exerted. I mean, that's what we really are. There's no way to know what of the lies or trickery affect the defendant. And so it's a truth. I mean, sometimes even the suspect won't know what it is that influences him to do it. He's been told that by trickery and induced, it seems then there needs to be that bright line rule. And this is a truth that should intellectually really doom the totality of circumstances test. And Judge Weisbard then sort of went through the change that went from Bram to the test that we now use. So it's time, we believe, for New Jersey to really adopt the Bram thing and stop any of that. As one of the authors of the new Miranda in SMU Law Review pointed out, the police are always better off to obtain a statement in violation of Miranda rather than honoring the Miranda invocation. And until proper deterrents are put in place, no Miranda warning, no matter how well drafted, will completely protect the amendments. That's why the totality of circumstances case needs to be abandoned. We have asked for the court to appoint a master or a conference to review these issues and to formulate new Miranda warnings. And for just briefly, let me tell you the kind of thing that ought to be studied. The objectives, what I want to do is tell you briefly, the objectives of the reform, the problem and the solution, and give you one example of how we can cure all of the Miranda problems. And I can do it quickly.
Gilbert, can you do that in 2 minutes?
How about 5, Judge?
I'm afraid not. We have your brief. You're an amicus.
This isn't in the brief, and I think it's important, but I'll stop now if the court prefers.
No, I want to ask you to cut to the chase.
Okay, I am. I will cut to the chase. Here's the objectives of reform: are you want to have full meaning to the people, but you don't want to have an explanation that's complex. It's got to be simple. So the way to do that, frankly, is through a tiered use. And that's the solution. Different rights are relevant at different stages of the suspect police encounter. The right to stop answering questions once questioning has begun cannot possibly become an issue until the suspect has decided to waive his rights. So getting quickly to the chase, 3 parts, okay? 1, the form. Here's what the interrogator says. I'd like to ask you questions describe the allegation. Before I ask you questions, however, I need to inform you of some very important rights you have. You have the right to remain silent. If you decide to talk to me, anything you say can be used against you. If you decide to remain silent, your silence cannot be used against you. If you know you want to be silent, we stop the interrogation now. But if you want to talk to me, or you're not sure you want to talk to me, I'll tell you about some additional rights that you have before you make your decision. Then there's a box. You check 1 box. I want to remain silent, and I understand my silence cannot be used against me. Or 2, I might want to talk to you and answer questions. Please tell me more information about my other rights. Okay, part 2. I will now, if the not stopped and he goes on, I'll now inform you about additional rights. You have the right to an attorney. If you cannot afford an attorney, the judge will give you one for free. You have the right to consult with your attorney before you decide whether you want to talk to me. If you consult with your attorney and decide to talk to me, you have the right to have your attorney with me when you talk to me. 3 boxes, you check 1. Knowing these additional rights, I want to remain silent. Or I wish to consult with an attorney. Or I understand these additional rights, but I want to talk to you without. And obviously, in 1, the interrogation stops. In 1, it ceases until he sees the attorney. In the other, we go to Form 3. You've told me you want to give up certain rights and talk to me. I will need you to sign and fill in the information below. The rights that you are giving up by talking to me are the right to remain silent. Again, if you decide to remain silent, it cannot be used against you. The right to consult with an attorney before and during the question. And if he's waiving all those rights, the right to, I've decided to talk to you. I understand anything that I say can be used against me in court. And finally, I also understand I can change my mind and stop this interrogation. You adopt a procedure like that, and I submit that you have solved most of the issues that come before you. And perhaps one last statement that I sort of omitted, because the test that's provided, the totality of circumstances test, doesn't give you anything for stare decisis. You can take the exact same interrogation constitutional violations, and in one case, because of totality of circumstances, it'll be not suppressed. In another case, it will be suppressed. All it does is breed litigation because there's no bright line rule. Thank you, Your Honors.
Thank you, Mr. Silver.
Lunchtime.
Ms. Gottesman, I don't want to rush you. You've respectfully waited until this point. About how long would you anticipate for your presentation?
I have 5 minutes prepared, Your Honors.
Let's have at it.
Thank you. Good afternoon. Now, Your Honors, there's been a great deal of discussion today, of course, about the necessity and viability of a per se rule. And the Innocence Project, like my fellow amici, is urging this court to affirm the decision below, and in so doing, adopt a per se rule. But our ask is slightly distinct from fellow amici's ask. So if I may define precisely what we're asking for and then state why we believe it's a necessity. The Innocence Project urges this court to create a rule that confessions obtained by intentional police lies are involuntary per se. This rule would prohibit police from falsely telling a suspect that their confession will be confidential, or that a confession could only help, not hurt them, which is what the respondent was told here. But it would also prohibit police from lying to suspects in their custody about the evidence against them, a highly coercive tactic known as the false evidence ploy. And before I go further, I'll just note that I plan to rest on my brief with regard to the Miranda trivialization issue, and I'll focus on these intentional lies, unless the court has questions for me on that issue.
Just one, and that is, do you agree that the third principle the third example, false evidence example is not part of this case?
I agree that it's not apparently so. I would submit that a sort of a further review of all the discovery and the evidence in this case would need to be undertaken to understand that. There were references, for example, to witnesses that the police spoke with, as well as text evidence, messages, and as Amici, I'm not.
On the record that we have before us,
Yes,
it does not appear that false evidence is part of this case.
that's correct, Justice, yes.
So as an amicus who comes here to help us with the matter that is at hand, I'd urge you to tailor your arguments accordingly.
Yes, Your Honor. I would submit that what is squarely before this court is an intentional police lie, and that is what we were asking the court to rule on, to rule that intentional police lies, such as what is at issue in this case, would render a confession per se involuntary. And our position is that that rule may sweep slightly beyond the facts of this case, but that it is squarely presented before Your Honor. And that such a per se rule is necessary in order to meaningfully deter officers from lying during interrogation, and that lying is not needed to elicit reliable, truthful confessions. Indeed, it's not used in many other countries outside of the United States, and yet this court has seen again and again, even among the very rare cases that make it before Your Honors, that in New Jersey, officers do lie to suspects and continue to use deceptive tactics even after this court has expressly condemned them. And under the current totality of the circumstances test, trial courts, of course, have broad discretion to admit confession evidence that was procured by deliberate lies, so long as there are other factors that point toward legal voluntariness. Stated simply, if the legal test remains unchanged, police deception will continue. And due to the exoneration of hundreds of people who have falsely confessed to crimes they did not commit, along with the accumulation of decades of social science research regarding interrogation coercion, we know today that when police lie during interrogation, innocent people are at a significant risk of confessing to a crime they did not actually commit. We know this to be especially true with regard to young people and the mentally disabled. And perhaps most importantly, what we've learned over the last several decades is that lying is not necessary for effective police work, and that there are ways to prevent against false confessions. Prohibiting police deception is one of the most impactful ways to do so. Now, nearly 30 years ago, in 1993, this court in State v. Galloway, of course, applied the totality of the circumstances test to a custodial statement that was elicited by a deliberate police lie. 1993 was just 4 years after the first DNA exoneration of a person who had falsely confessed. It was just a few years before scientists had even invented the laboratory paradigm that is used to study the psychology behind false confessions. And it was over 15 years before the seminal white paper on false confessions was even published. And so, in fact, in hindsight, with all we've learned over the last many decades since Galloway, we can see that the very reasoning behind Galloway was frankly mistaken. In that ruling, the court stated that unlike physical coercion, quote, a psychologically oriented technique during questioning is not inherently coercive. And this reasoning, adapted from an older opinion, Miller in 1978, is now effectively debunked by the science and the data on false confessions that show that lying, in fact, is indeed, quote, inherently coercive, if not powerfully manipulative. And of course, police lies don't happen in a vacuum, right? The suspect's taken to a police station, they're isolated in a small room, they're confronted by multiple armed officers who have already decided that he's guilty, so they reject any assertions of innocence and insist in his guilt while suggesting that the crime is understandable or justifiable, and imply that leniency will be forthcoming upon confession, and that leniency can only be awarded if the confession is elicited now, in that room. This is by design. It's an attempt to convince the suspect that confession is the best, if not only way out of the coercive environment. And within that context, it's perhaps easier to see why lies like those at issue here can make an innocent person feel compelled to go along with the interrogator's narrative and insistence that they confess. Because, well, what's the real harm if it's confidential? If it will end the stress of the interrogation? And if I'm innocent, well, won't the truth come out at trial and show that? And when the lie is about evidence against the suspect, again, I recognize not at issue here, but quite similar in its impact, it can be so powerfully coercive that a person can begin to question their own memory and even their own guilt. And if the court would indulge me to just briefly consider the case of Marty Tankleff, a former client of ours. Marty, when he was just 17 years old, was interrogated about a violent attack on his parents that had occurred just a few hours earlier. The interrogating officers lied to Marty. They told him that his father, who was actually in a coma, had woken up from the coma and told the officers that it was Marty who had committed the violent attack. Hearing this lie, Marty thought, well, my father never lies. Why would he say this? Maybe I am guilty. Questioning his own guilt based on that lie, he told the officers, well, maybe I blacked out and committed that offense. Under the totality of the circumstances test, that statement about Marty indicating that he may have blacked out was admitted into evidence. Marty was wrongfully convicted and spent nearly 2 decades of his young life in prison before post-conviction evidence demonstrated his innocence and pointed to the true perpetrator. And to wrap up, I'll just note that in recognition of how coercive a police lie can be, courts and lawmakers around the nation are heading in the direction of creating rules to prohibit police deception. This court has been a leader in evolving its state law in a manner consistent with science and to help protect, its citizens from the injustice of wrongful conviction. So to safeguard against false confessions and assure that only reliable confession evidence is what's presented to fact finders throughout this state, this court should affirm the decision below and hold that confessions produced by intentional police lies are inadmissible per se. And unless there's further questions, I just want to thank the court for allowing the Innocence Project to participate and for consideration of our brief.
Thank you, Ken.
Thank you.
Mr. Ray, can you bring home rebuttal in 3 minutes?
Yes, Your Honor, I'll
Please do.
make it 2.
Nope, even better.
Your Honors, I'd just like to correct some factual inaccuracies with respect to the defense's presentation. He stated that defendant was in the hospital for 3 weeks, but that was defendant's testimony. It was specifically rejected by, his testimony was rejected by the trial court. The BCPO detective, who the court found credible, testified it was only a week and a half. That's on the July 2017 transcript on page 42, lines 11 to 12. Defense counsel also brought up the fact that defendant was heavily medicated, but the record only speaks to defendant taking Zoloft. He confirmed at the interrogation that he was only taking Zoloft, as well as the Miranda hearing. And in any event, the detectives confirmed that he was level-headed and clear before they started questioning. The next inaccuracy I'd like to point out is that the police, quote, grabbed him and brought at the hospital. The defendant agreed to go to the police station with the detectives, and the court also rejected defendant's testimony that he was handcuffed. Now, with respect to the recordation requirement that the defense counsel cited, the defendant asked for the recording to be turned off, but he didn't say that he wouldn't speak to police unless the recording was turned off. So that exception that was cited by defense counsel respectfully doesn't apply. I'd just like to end by stating that while there were police misstatements in this interrogation that were improper, this is a very rare case, and it's rare for several reasons, but I'll focus on the 2 that I continue to remark upon in my statements to the court, which is that defendant had a prior experience with police interrogation. He stated that he spoke to police in the past. It didn't work out in his favor, so he knew that his statements could be used against him, and that the BCPO detective corrected the misstatements by the Hackensack detective. So this is a rare case where we have those 2 considerations, just to name a few. To conclude, the trial court and dissent were correct, that the Hackensack detective's improper comments didn't undermine defendant's understanding and appreciation of his rights. Thank you, Your Honors.
Thank you very much. And thank you to all counsel.